Goswami?
Should notice at the moment, not detailed information. Otherwise, the petitioner has preferred an appeal also.
Where's the appeal?
Before the commissioner, and earlier the petitioner filed a race petition whereby a direction was given to file appeal before the commissioner. Accordingly, an appeal was filed, my lord. Nothing was done for that. We have already filed petition. Here, my lord, in this case, my lord, the petitioner was for the direction interference of this honorable court regarding, my lord, the fact that the name of the petitioner's school has been, my lord, deleted, my lord, from the list of schools, my lord, for receiving incentives. Incentives who have participated and secured A class in units of matter. And also annex the certificate at page 43, section G. It is the page, addition F, page 40.
Yes.
The prayer portion, consequently is multiple. Prayer of the appeal. And the prayer of this instant petition.
That is different, madam. That is regarding amalgamation.
Different.
Appeal is regarding amalgamation.
But Ms. S.P. Chowdhury and counsel for petitioner. Issue notice. Mr. B.N. Sharma and standing counsel. Elementary education affairs for respondents 1, 2, 3,
4, 5.
and 5. Stop. And Mr. Bogalan and government affairs for respondents. Notice and respondents of complete respondents are not contrary. List of the polls.
Three.
Yeah, this is everybody order with 718 transparent director of 7 we have to be in the remove from measurement 71 you also directives to operate instructions whether to be conferred by US State University in Meghalaya, whether it is its applicability in state of Assam. Persons that we have placed an instruction matter.
Where's
I have subject popular. Dated 1/6/2019. It has been written by the Joint Secretary to the Government of Assam, the Honorable Chancellor UST in Meghalaya. And it says, in inviting the reference to letter on the subject cited above, I am directed to state that once a university is recognized and empowered by the UGC, following establishment by an act of the Legislative Assembly of the host state, it does not need any further empowerment from us, nor does it require in our concurrence. Thus, DDTP, including PhD awarded by USTM, is acceptable so long as USTM adheres to its laid-down rules, regulations, and ordinances. From the last directors to include NCT as a party, to keep them by structure number.
have you taken steps?
Yes, sir.
Okay. Third, Mr. B.D. D. Colliton and counsel for petition. Issue notice. Mr. U. Sharma and standing counsel.
1, 2, 3.
Secondary Education Affairs for Respondents 1, 2, and 3 and MS Council appealing on behalf of R. Ali. I Alam, Leonard Standing Council, NCTA appears for respondent number 4. Extra copies, notice and responses are complete. Respondents are not complaint. This is the matter after 4 weeks. Pendency of this writ petition shall not be a bar upon the respondents to consider the case of petition.
Four.
And this is page 7, paragraph 5.
Hmm.
Reason for why this amalgamation is pending on.
1 minute. Yes.
Madam, madam, we have accused to produce another report. This another report, madam, earlier, part is about page 51, madam. The another report directed the responding authority to dispose this matter after taking hearing.
1 minute.
Page 51, madam.
Yes.
So, madam, there is a time frame stipulated by this another report so that they can dispose of our appeal. Accordingly, we have filed appeal. However, there is no specific direction given that the responding authority should continue this school in our premises. So, accordingly, my lord, due to this, by showing this reason, my lord, they did not have promotion in our school.
What?
Promotion is already held, my lord. And our students is deprived of promotion, my lord, because they did not go that particular school, my lord, where the school is allowed to be. There are only 16 students. And this is a hilly area, my lord. The academic environment will be initiated by students. Students are deprived of the national right. So, I approach the position of the court by the student art school. Before the disposal is settled, my school may be continue our school right. Specific election will be given to the respective authority.
Yes.
By the time is that
Being some-
they have preferred appeal. Now, the government has formed a joint committee for resolution. If any party or any person or any student accused by the order of the amalgamation, there is a committee formed for re-verification of amalgamation and merger of the schools. So that process is there. So,
That process is on.
there is a committee also.
Has the committee given its report?
Lawsuit?
Committee has given its report or not?
No, lawsuit. The secretary of the education department, Professor Assam, has formed a committee for the verification of the merger and amalgamation of if any party, any schools, any person is agreed by the amalgamation or merger order, they can prefer an appeal
That's
before the
good.
committee. That committee is formed. So they have to prefer this appeal before the committee and they will verify. Verify. If any person is agreed by the order of amalgamation or merger. So minor page 55 is there. Pursuant to the honorable court, so that we can prefer appeal. Page 55.
Appeal is filed before the secretary. So let him.
The direction to the secretary to place it before the committee and dispose after giving details. So my humble submission is that this is an administrative procedure that can be done. My submission, my students are different of education at present. So at least students may be protected by this. We would decide that appeal may be disposed of or not, that may be continued. This is not our concern. Our concern by the students are deprived of already deprived of that workshop and now deprived of education. Students are not paying. So by that protection will be given to the students because before disposal of this application. This is the question of the students' education. This is disposal of. Also direct. Disposal of the election will be given to the PU and PU also the committee. They are showing that the order is given to the secretary, not ours. So election will be given to the district officer also, PU and PU also. So that school may be continued.
Okay, heard Mr. HR Chandran, then the counsel for petitioner, also heard Mr. Ben Sharma, the standing counsel. elementary education for respondents 1, 2, 3, and 4.
4 and 5. All the
For all the respondents. Stop. Para. The petitioner who's the petitioner? Is the president of the school managing committee of Amaitila LP School and is aggrieved by the notification dated 30/4/2022. Where's that notification? By which the Amatila LP School has been merged with 117 Raman, what is it? Ramanabad LP School. On the ground that the school is having an enrollment of 46 students, whereas the Ramanabad LP School is having only 16 numbers of students. Stop. The further ground of the petitioner is that the petitioner school have sufficient land situated in plain geographical area, whereas the 1117 number Ramanabad LP School is situated in a hilly area. Stop. And the petitioner school is situated within the village, for which the village students can easily visit schools. Whereas the 1117 number Ramanabad LP School is situated in a different village named Ramanabad. Stop. The further case of the petitioner is that the 1117 number Ramanabad School, LP School, is situated at a distance of about 1 kilometer from the petitioner school. Stop. Being aggrieved, petitioner had earlier approached this court with this court's order by filing WBC number 7186 of 2022, which was disposed of by order dated 23/11/2022, directing the petitioner to file an appeal, to file a fresh appeal, public representation before the Secretary to the Government of Assam in the Elementary Education Department on or before 9/12/2022. Stop. In the event of filing such appeal by the petitioner, the Secretary to the Government of Assam in the Elementary Education Department shall dispose of the said appeal on or before 31/3/2022. That is yet to come. 31/3/2022 is yet to come.
Yet to come.
Why is it?
I am minor for the sake of students. The school is not going on minor. The school, the students' application is being right now. Also, that re-verification process is going on. Also, minor specific direction for the sake of students, and not for that. That can be done.
Then I'll issue notice. I'll give you some protection.
Protection will be.
Or cancel the whole order. HR Dawdil and the concept of petitioner issue notice. So why should I issue notice also?
Minor, at least after taking this appeal, minor. They have
No,
not
time is still there. 31/3/2023.
Time is there, man. How much the student, the petition itself is premature now. They would turn the teachers. Accordingly, minor students are deprived of production, already deprived of that.
Okay, I'll do one thing. I'll continue with the order till 2023. Stop. Pursuant to the order dated 23/11/2022, passed by this court. Petitioner filed an appeal, representation dated 7/12/2022, before the Secretary School Education Department, which is still pending disposal. Stop. Para. On consideration of the order dated 23/11/2022, passed by this court in WBC 7186 of 2022, the period for disposal of the appeal has been fixed on or before 31/3/2022. The said period is yet to expire, and accordingly, I'm unable to accept this present petition. And accordingly, the same is dismissed. However, till the appeal is disposed of by the Secretary School Education Department, the students of the Amatila LP School shall be allowed. The Amatila LP School shall be allowed to hold the Gunotsav in the school till the disposal of the appeal by the respondents. Stop. That much.
CEO may be directed to and then the features of that school. CEO may not. District limited.
No, I just said Gunotsav should be held, nothing.
5.
What is it? After some time?
6.
Majumdar, you are appearing in this matter? Have you received instructions? No. None appears for the petitioner list after 1 week.
Of supplementary list.
Where we select the same manner as on an order. But in this manner, the ATV like never after some time.
You file your affidavit, Advocate General?
No, till now the notice has not been issued.
No, last occasion, there was a reporting that you will be filing an affidavit.
We have received the complete instructions last night. If that we can. That's not the evidence. We have filed. And then Lordship will first hear on the point of maintainability today itself. Who allowed? We will allow everything. The maintainability. Whatever it is. Till now, notice has not been issued. How can we file an affidavit?
Here, there's a reporting, there's a reporting.
And the other two, the documents, because last 5 days, there is not a single officer in the office. Everybody is busy with the G20 summit. I'm getting expert comments from the other side. This is very difficult now.
Just a minute. Here it says, Mr. Cycle.
I definitely do.
Yeah.
And by 2 o'clock, we can file a affidavit. By 2 o'clock. We'll find it.
Then we'll take up it.
I'll not go back on my words. I'll not go on my words, but I'll file the 80 by 2.
And just start my case because I have been trying to at least place the things I have not been able to succeed. Let me place my case, at least your lordship should know. And there is a development which you have brought into record by an additional affidavit. But I am not placing that straight away because your lordship needs to know the background so that your lordship can appreciate this which has come from the authority itself. But this relates to a homeopathic college. There are 3 homeopathic colleges in the state of Assam. One is at Jorhat, one is at Nagaon, another is at Guwahati. They are recognized under the law. There is an act to cover the homeopathic institution, first enacted in 1973, and thereafter it was superseded by another act which is in 2020. Therefore, the entire field is, this is a parliamentary legislation, it is all covered under those 2 acts of parliament under 1866 of the first. Now, these are recognized under the act and the regulations present. We are the Jorhat College in disorder. It's a recognized institution. The scheme of the act is because there is a apex body which is called the Commission of Council of Homeopathy and 3 advisory boards. It is called boards. Assessment, infrastructure, professional ethics, and their functions are stipulated in the act itself. The act contemplates certain standards because under 1866, for medical colleges, this, you have to fix the standards. So that is what is their power under the act and the regulation to fix the standards, to determine the number of seats which can be allotted, their increase or decrease, and their functioning, which will be assessed periodically. There is no provision in this act for amalgamating recognized institutions. Neither the state government has that power, nor the authorities contemplated in the statute has that power. Then the question is around how will this recognized institution disappear, if at all. The only provision is there which says that your recognition can be withdrawn. Why it can be withdrawn? The Act specifies. What is the procedure you have to follow? The Act specifies. And the authorities are earmarked in the Act itself. Therefore, in that scheme, the state government has no place. It's entirely the council and the advisory boards and their assessing authorities who will, if there is some complaint in functioning, they will issue notice. But even the authorities under the Act have no power of amalgamating an institution. One with the other. They can only withdraw the recognition, which will mean that it will cease to function. Because you can't have degrees if you are not recognized. Therefore, nobody will come to you. Therefore, this is the only way a recognized institution can disappear. Here, what has happened, without reference to the entire 3 bodies under this Act, the state government is initiating a move to amalgamate these 3 institutions, namely Nagaon, Jorhat, with Guwahati. Now they take a decision, thereafter appoint a committee to report. That committee report comes supporting amalgamation, which as per their own documents was taken earlier. They put the cart before the horse. Now, after that, they pass the impugn orders, say that this two institutions are amalgamated with one homeopathic institution. And when we come here, they pass an order asking the students to move out. The Jorhat College is the only college where there is a hostel for boys, hostel for girls. Guwahati doesn't have that. The number of seats are equal, which they can have 63, 63, 63. Now, if you add that, it becomes 189. There is a restriction in the regulation that you can't have more than 100 in one college. Now, they don't even refer to the main authorities under the Act, the advisory board for assessment, the commission which is there. They don't put forward their proposal before that commission. The state governments are parties in the composition of the council. They were done. Now, in that situation, we move. Now, this court has not yet passed any orders here, effective. Now, the position is, we have received now this, which we have just filed today, because we got it yesterday. Right. It is also of 6th February. Therefore, we file an additional affidavit to annex this document. Now, kindly go through this document for a minute.
Which document?
Additional affidavit we have just filed. It has been handed over. And I shall aim. It is medical assessment and rating board for homeopathy. But I just read this later. It is of 6th February. Yesterday it was passed. It is addressed to the Registrar of the Srimanta Samparadeva University of Health Sciences, Narasapur, Hilltop, Mayanmar, Commerce. Subject is amalgamation. At the top of your worship can see National Commission for Homeopathy. That's the effective body, central body. It is informed as per above mentioned letter that 3 government homeopathic medical colleges, mainly the one at Guwahati, the other at Nagaon, and the third at Jorhat, will be amalgamated and one government college, Sahib Jadavnath Homeopathy Medical College and Hospital, Guwahati, will be functional from the academic year 22-23. Medical Assessment and Rating Board under NCH, National Commission for Homeopathy, has examined the decision taken by the government of Assam for closure of 2 homeopathic medical colleges and the amalgamation with Shahid Medical College at Guwahati, and the following observations were made. Government of Assam has not made any primary evaluation of the facilities available at Shahid Jadavnath Homeopathic Medical College and Hospital, Guwahati, to occupy 3 colleges and its functional aspects in one premises. It is observed that the affiliated universities of these 3 colleges, or NCH, that is the National Commission for Homeopathy, as regulatory authority, were also not consulted in this regard before taking this decision. If university had conducted any inquiry or inspection, such reports were not endorsed to the National Commission for Homeopathy. As per prevailing regulations under the NCH 2020, one homeopathic medical college should not admit more than 100 students per year. The infrastructure, teaching faculty, hospital functioning, etc., will be badly affected by closing down 2 colleges. If the college is supposed to accommodate 3 institutions should be able to host all equipment facilities to keep teachers and supporting staff for school functioning of the college. As you are aware, closure of two homosexual colleges in Assam may cause wider resistance from the society since Dr. J.K. Sarkar and Assam HMC have been functioning under the government of Assam for a long time. The matter of amalgamation of the colleges by Assam government is being discussed in the forthcoming meeting at MCH, proposed to be held in February 2023. The decision of the National Commission for Homology will be communicated to you for necessary action. Your comments in this regard are invited within 15 days to enable MCH to decide further on permission matters and recognition of these three colleges. There is an act governing, there are bodies prescribed under the act, their functions are there, state government has nothing to do with this matter. They take a decision with amalgamate all three. These two colleges which are there, this Jorhat college is there for the last 47 years. They have all India quota allotted to these colleges, including Jorhat. 2 seats for all the neighboring states of Northeast. That is the NC NEC has provided funds for construction. 2 seats are earmarked for all this, including Nagaland, Bhubaneswar, and there are students from there. The 2 hostels are there where students are in occupation. Now, all of a sudden, without considering anything, without even informing the parent body, a decision is taken without any acting of law. There is no authority under this act conferred to the state government to amalgamate the recognized college. Where is that power? There is none. Even the National Health Commission is not entrusted with that power because the act only contemplates that it can withdraw the recognition. If that is so, then without even whether the commission, National Commission, the highest body can do or not is a matter of which has to be decided if they at all take a decision. But as of now, the act is silent, the regulations are silent on amalgamation. The only provision I find is that they have the power of withdrawing recognition if the functioning is not acceptable or if they have not performed in terms of the action. That is not confined of the state, that is of the primary authority under the act. Therefore, if your lordship is that, they will look at the act and the scheme. From your lordship, if you already dictate. Central government shall by notification constitute a commission to be known as National Commission for Homeopathy to exercise the power conferred upon and to perform the function assigned to it under the Act. That's the current body. The commission shall be body corporate in all that. The head office will be in Delhi. The commission will consist of persons, namely chairperson, 7 official members, and all that, and 19 part-time members. I'm not troubling your lordship with all the details. There will be a search committee under section 5. And kindly come to section 8. Section 8 below, the secretariat is contemplated to the secretary. And then kindly see the functions. The commission shall perform the following functions, namely, lay down policies for maintaining a high quality and high standards in education of homeopathy and make necessary regulations in this behalf. Lay down policies for regulating medical institutions, medical researchers, and medical professionals and make necessary regulations in this behalf. It is all conferred on the highest body below the commission. Normal policy decision practical assess the requirements in healthcare, including human resources for health and healthcare infrastructure, and develop a roadmap for meeting such requirements. Frame guidelines and lay down policies by making such regulations as will be necessary for proper functioning of the commission, autonomous boards, and the state medical councils of those to ensure coordination among autonomous boards, take measures that will be necessary to ensure compliance with the state medical councils of homeopathy of the guidelines framed and regulations made under this act and their effective functioning under the act, exercise appellate jurisdiction with respect to decision of the autonomous board or decisions of the main body, which is the commission. Then the advisory boards come under section 11 below. 3 advisory boards are contemplated, and their functions are 2. In section 12 below, the councils are the primary platform to which the states and union territories may put forth their views and concerns before the commission and help in shaping the overall agenda, policy, and action relating to medical education, training, research, and development home. So it is, if the state has some views on a matter, that contemplates that you place it before the council. Policy is to be decided by them. The states are allowed to give their views on any matter, and you'll also have gone through a letter which I have just said. State government never bothered to even inform them. That's the minimum standard in subsection 2, the council will advise the commission below. There is a commission also specified. Then without the contemplation is just like a medical college admission, without college examination, and then allotment of seats as determined by the council for each of the institutions located in various parts of the country. So that is taken care of, national examination. And that examination so far these 3 colleges are concerned, and 63 seats each, altogether 189. 16 contemplates that national uniform, postgraduate, national entrance test also, and the earlier clause below because there is national graduate level. Then national teachers eligibility is concerned. Then 18, the constitution of the central government will constitute these 3 boards: Education Board, Homeopathy, Medical Assessment and Rating Board for Homeopathy, Board of Ethics and Registration of Homeopathy. So this is again a part of the central government, and 3 boards are there for their respective functions which are prescribed. Now kindly turn to give 26 for a moment. Homeopathy education course shall perform the following persons, namely functions, determine the standards of education at the undergraduate, postgraduate. So this is the power of the book. And frame guidelines, determine minimum requirements, determine the standards and norms for infrastructure. All this is covered by which is conferred on the board. And kindly turn to 28. Medical assessment and rating board for homeopathy shall perform the following functions, namely B. The letter which I placed below it is by that. Grant permission for establishment of new medical institutions or to start any postgraduate course or to increase number of seats in accordance with the provisions of section 59. This is the power of the Assembly Board. And 29 can you see, no person shall establish a new medical institution or start any postgraduate course or increase number of seats without obtaining prior permission of the medical assessment and rating board for university. Absolutely, the whole scheme is statutorily prescribed by a parliamentary law, and whatever the functions are, they are in university. Then below the thing is provided and all that. Then below section 30 is a indication of what the aim of the entire act is, because this is now 2020. The policy which has been restated, if I may say so, is to see an expansion of these medical systems. Allopathy is there, but Ayurveda and homeopathy and other Indian medicines, there is an attempt now to give and expand, because 70% of India lives in the villages, and it is very essential because our medical college doctors cannot, they are not distributed evenly. So we have a fix for these homeopaths in very many areas. We are able to help in propagating the healthcare system. Now, kindly see 30. While approving or disapproving a scheme under section 29, the board will take into account, these are the considerations they will take into account. The provider is very important. Provided it is subject to the previous approval of the central government, the criteria may be relaxed for the medical institutions which are set up in such areas as may be specified by regulation. Therefore, the idea is to expand so that where medical facilities are not available, all types of medical classes or treatments may be introduced so that people get facilities for health. That's the whole idea. You have allopathy, you have Ayurvedic, you have homeopathic, so it will be spread out so that people are at least having some kind of a healthcare system. That's the whole idea. Then I don't tell you also the registration of the things and the rights of the person. They have a license to practice and all that. Recognition of section 6, 35 onwards. This is the recognition part. Medical qualifications in homeopathy at undergraduate or postgraduate or super specialty level granted by any university or medical institution in India shall be listed and maintained by the Homeopathic Education Board in such manner as we will specify. Or recognized institution. Finally, that is section 27. Whereupon a report received from the medical assessment and grading board for homeopathy or otherwise, it appears to the commission that the kindly time to the courses of study and examination to be undergone in the proficiency required from candidates at any examination held by a university or medical institution do not conform to the standards specified by the Homeopathic Education Board. This is one round. Or B, the standards and norms for infrastructure, faculty, quality of education in medical institutions as determined by the Homeopathic Education Board are not adhered by any university or medical institution, and such university or medical institution has failed to take necessary corrective action to maintain specific minimum standards. The commission may initiate action in accordance with the provisions of subsection 2, provided that the commission shall before taking any action for suo withdrawal of recognition granted to the medical qualification awarded by a university or medical institution impose a penalty in accordance with the provisions of clause 7 of section 28. The commission shall, after making such further inquiry as it may deem fit, and after holding consultations with the state government and the authority of the concerned university or medical institution, comes to the conclusion that the recognition granted to a medical qualification ought to be withdrawn, it may by order withdraw recognition granted to such medical qualification and direct Homeopathy Education Board to amend the entries against the university or medical institution concerned in the list maintained by the board to the effect that the recognition granted to such qualification is withdrawn with effect from the date specified. So this is where how we are going to regulate the recognized institution. If these conditions prescribed are fulfilled, then there will be an inquiry and a decision taken to derecognize that one. So this is what with respect in respect to a recognized institution. This is the only way by which it disappears. There is no other provision which indicates that you have a power to amalgamate one with the other. Because what is happening if you do that is this. Think of this situation. A college of homeopathy started in 75, 47 years ago, recognized the person concerned, Dr. J.K. Chaitya, the first director of health services in Assam after independence. He gave his own land for the purpose of establishing a homeopathic college, assisted in building 2 buildings, and there was enormous contribution of the citizens of that town to build that thing, and it was established in 75. Now here, this order completely destroys the identity of that institution. It disappears. A recognized functioning medical institution with hostels, which these hostels, these colleges do not have, with hospitals, outdoor, in Jalupani, that is in Chittabur, so Lordship will know, they have a herbal garden and enormous enormous activity for the entire area. And people are benefiting for the Upper Assam as well as for the nearby states. Therefore, you by this stroke of pen ensure that it doesn't cease or it ceases to exist at all. You take it off. It goes, it vanishes. Do you have that power? Where do you have that power for a state government to do that? Without consulting this commission, which is a prescribed body at the highest level of the act? Is it a joke? That you pass an order and you where they have passed the orders and show it to logic order. They take a decision with amalgamation, then form a committee. There's a report from them. And amalgamation takes place without even telling the concerned body. And our direct students go. Now, there will be local people from outside the state of Assam has come. They will be staying. There is no provision for a hostel stay in Guwahati College. It's absolutely bizarre sort of exercise. The power which they don't have at all. The act doesn't confine the power of the state government to do this.
Where is the impugned order?
Kindly see the impugned order. There are quite a few of them. The order is at page 44. If I hear what it should be interesting. And let me take your last to the document, then go with it. The first letter is at page 33.
Yes.
This is CD date 2/10/22. Turn over to page 34. Second paragraph of that. In this regard, it is to be stated that a meeting was held on 19/10/22 under the chairmanship of Honorable Health Minister Assam regarding amalgamation of 3 homeopathic colleges in one. And it was decided to close the admission of the Assam Medical College Hospital, Nagaon, and Jorhat JK Saika Homeopathic College at Jorhat for the academic season 22-23. This decision is already taken on the meeting of 19/10/2022, and the letter is dated 2/10/22. We have given the original also, that is at page 35. Then we will kindly see 21st of October 22, they form a committee for the proposed amalgamation. Then they give the at page 37 a report by the committee, brief note on the 3 medical colleges. The interesting part is here at page 38. First is the serial is Guwahati, then the second is Nagaon, then the third is Jorhat. And then at page 38, if you will just kindly see B. Again, the 3 colleges. Kindly see, so far as Guwahati is concerned, they are giving the details in square feet. come to AK Soikia, it is in square meters. 1 meter is equal to 8.764 square feet. There is an attempt pillar of a projection of a smaller institution. Whereas we not, this is a bigger institution with 2 hostels for boys and girls, which I mentioned. But the areas I am only indicating, the about attempt to close these institutions without any rhyme or reason. And then they go and they were really not concerned with the facts, because the whole question really boils down to whether a recognized institution can be amalgamated, number 1. 2, can it be amalgamated in the way it has been done? 3, if you don't have the power, without reference, which is very clear from this letter, which and it takes first instance, the body concerned says you have never bothered to tell us what is happening. And ultimately at page 41, justification for amalgamation is student enrollment for the last 3 years is less. That last say is very soon out of the capacity 63 numbers in each college. So it is 30, 2018-19, 2019-20, only 49, 2021, 75 in 3 homeopathic medical colleges of Assam out of the total 189 every year. Because 1890 last 3 years, you are the position of what was happening in the country. But that is not even a relevant consideration. As your Lordship has seen in that section 29, the government of India says that we can relax rules if it comes to expansion. That is the whole idea. Then this order comes to the Government of Assam, page 44. That is the made into an order. This was the inquiry they made, which I your Lordship has already seen. The authority concerned under this statute says that we have never been consulted at all. Now, this is the order. In the interest of public service, the Governor of Assam is pleased to notify the amalgamation of free homeopathic college and hospitals of Assam, the names are given, into one single homeopathic medical college in Guwahati, that is the so-and-so at Guwahati. At the campus of the existing college, with the name, same name and location, with immediate effect, in line with the following structure and modus operandi. Therefore, these two will come, we amalgamate them, and it becomes one. We lose our identity, we lose our institution, and everything is gone. For the last 47 years, they were in existence. A recognized institution. The amalgamated homeopathic medical college so shall be a state-of-the-art homeopathic institution in the state. The institute shall start its functioning from the existing premises of so at Guwahati. We don't mind, we don't have the art of whatever they say, state-of-the-art institution, we'll be very happy to have it. Have it. But why do you at the cost of these two? That is why at the cost of the best medical institute with infrastructure. I can imagine somebody coming and getting amalgamated with the best or the bigger one. Or a bigger one is being taken to the small one without hostels, and you direct these boys and girls go and report there. start studying that. The Amalgamated Medical College Swindon and the State of Art Homeopathic Swindon. Classes of all homeopathic colleges will start functioning from the amalgamated colleges. Also, with effect from the session 22-23, the classes of any particular session currently functioning in the three number different homeopathic medical college shall henceforth be accommodated in one single class room for them. That's why they are saying that your limit is 63. You are going to add 63 plus 63 total 189. How are you going to do it? But who bothers? Because this still thinks it has all the power everywhere. That is the problem. They don't look into the acts commanding the institutions. Then in case of classes of all the sessions, and this is all optional. Moving the National Commission for increasing the number of seats. You give up your seats for the two colleges and then say that we will move the commission to increase the number of market seats. And the students are disrupted, they will have to go and face all the problems there. All the posts of faculty, grade 3, grade 4, staff shall be shifted to the amalgamated college. So the other workforce position shall be arranged by the director of our and all these now, the shifting of lock, stock, and barrel. Men matter, property is everything.
Yes.
One second, he has everything to say because he is I'll just complete. That is all. I think consequential orders to that effect will be all of them. So, person to this page 44. So, the entire thing is a recognized medical institute. The Act doesn't contemplate that it can be amalgamated with them. There's no problem. The only provision which is there is for withdrawal, if the conditions are satisfied. Beyond that, there is nothing. Withdrawal is recognition. That means you are putting it off because you have not been functioning. That's the only provision made. Now, kindly have a look at section 44, 47. That's very important. Notwithstanding anything contained in this act, any student who was studying for a degree or diploma in any medical institution immediately before the commencement of this act shall continue to so study and complete his course for such degree or diploma, and such institution shall continue to provide instructions and hold examination for such students in accordance with the syllabus and studies as existed before such commencement, and such students shall be deemed to have completed his course of study under degree or degree in this act, where recognition granted to a medical institution has elapsed, that is one, where the efflux of time or by voluntary surrender or for any other reason whatsoever, such medical institution shall continue to maintain and provide the minimum standards as approved by the Commission till such time that all the candidates are able to to complete their study in that institution. That's the provision. If it has to go away also for some reason, it lapses, you recognize. Even then, 47 requires that you continue that institution. The students studying there have to be taught, and they will complete the course in that institution only. That's why I'm saying, the only an express provision is not there with regard to amalgamation. Even this continues, this contemplates and indicates that when recognized institute, otherwise must continue. Even if this happens, it will continue to complete so that the students are not affected. That's the purpose indicated. And just see what has been done. By one stroke of pen in the manner they have done, a 47-year-old institution is vanishes. It loses its identity. Think of that family who donated their good land for this purpose. Think of the entire enormous money which came from the NEC. Think of the plight of the students. And think of the healthcare which the public will be missing. It is not just in one place that you want the state-of-art hospital. These hospitals are providing a very important service to the society. That's why the letter says that it will have great ramifications in the places. It will have great ramifications so far as Happara is concerned. It's not merely confined to the district. All over, people will come. People should come. Even for neighboring states. 2 seats are allotted for each of the states. Therefore, in my humble and respectful submission, first of all, and it's an absolutely legal issue. Do you, as a state, have the power under the Act to amalgamate a recognized institution without reference to it? And it appears they have done. And in violation of all these provisions which I have said. My friend is appealing to the other petitioner. Actually, I represent minority students union. The secretary and minority president, secretary and the president. In that matter, we have earlier last week. We filed an IA for impeaching ourselves in my lord Mr. Swami's case. That is in the list, my lord. I don't pay for that because till then we were not having the access to some latest documents. After having access to latest documents, my lord, we have also filed an independent writ petition, which is being tagged with this writ petition. Whatever submissions and my lord, illegality without authority, without jurisdiction, etc., has been submitted by my current friend. I completely endorse. As the students, my lord, lordship, see, this petition is item number 40. Item 40. Well, writ petition 644 23. Lordship, kindly have a look at page 55. Next one. This was issued on 31st January. And that I am not that I am not special. That is also an because since now it is independent writ petition I am saying. Here, my lord, 2 documents which are, my lord, entirely relatable to the students. Page 55, a notice was issued on 30th of January 23. It is hereby informed to all students of MC Nogao and so Jorhat, who are now students of Amalgamated Homeopathic Medical College at Guwahati, shifted by the Union Order, that their classes will be started from 1st February at so and so. The students should attend their classes regularly to get their requisite percentage for entering university finalization. So, we 63 students, many of them are in hostels. And my lord, from the other villages and maybe from poor economic background, they have to come here, take a room at a hotel, and then comment their rest of the syllabus at gone.
Classes have started.
Classes has not yet started. Classes have, we have not come. We have come before your lordship. How can a minor student with ordinary economic background is staying at a very nominal rate in Durham, homeopathic college, come and attend classes here by staying in a hotel in Patalgaya? And moreover, apart from the fact what my learned senior Mr. Goswami has submitted, that I submit after endorsing all his rounds of charades, my lord, I simply say that the decision, the proper decision, apart from being without authority and jurisdiction, state does not have a jurisdiction even to formulate whatever policy decision versus amalgamation. This is absolutely, apart from illegal, it is absolutely irrational and absurd. And when it is irrational and absurd, in 226, boards interfere. This should be my apparently absurd and my lord irrational. Medical college is fast that they will have to come. So, my lord, I am just pointing out one section of the act, which is already pointed out. Can you say section 10? Section 10, 28, and this 28 my lord, was published in the Gazette on 2021 September. It came into effect. Some of us are halfway through our minor courses. Some of the students of the 63 are halfway through the courses. 1 year left for completion. Halfway, and the provision has already been shown. But by Mr. Goswami, that they must be allowed to continue. Even if we discontinue or derecognize an institute, they must be allowed to finish their education in that particular institution where they have been undertaking their social studies for last 1.5 years. Section 10(1) of this act, page 6 of the Gazette. The commission shall perform the following functions: lay down policies for maintaining high quality and high standards in education and make necessary regulations in this area. Lay down policies for regulating medical institutions, medical research, and make necessary regulation in the state is not even empowered to move out any policy on its own. Where it is. Even by our policy decision is taken, if we not right under the law, we cannot take a policy. Who can take a policy? One who is authorized under the law and has the jurisdiction, then will be moved out. That is my submission. Give you the citation. AIR 31 Privy Council 248.
AIR?
AIR 31 Privy Council 248. It emphasizes the necessity of a backing of the law for any executive action in this term. In accordance with the British jurisprudence, no member of the executive can interfere with the liberty or property of a British subject, except on the condition that he can support the legality of his action before a court of justice. And it is the tradition of British justice that judges should not shrink from deciding some issues in the face of the executive. A member of the executive can only act in pursuance of the powers given to him by law.
Yes.
I'm getting the first petition, the second petition first. This is my learned friend. Learned senior for what I have. this has come for the first time. And according to him, they are students. The lordship is pleased to come to page 10. So they are on and on, they are issuing the issue of raising the issue of jurisdiction. The petitioners are the permanent residents of the above mentioned addresses and are citizens of India. They are entitled to all rights and privileges under the Constitution and other laws in force. And lordship will also come to page the box title. I will address all the issues on merit also, but technically lordship will have to be very clear. Page 7. Dr. J.K. Salgia, Homeopathic Medical College Student Senior, represented by its president, Turishma Salgia, maybe Salgia, and number 2 is the secretary. Sushanta Bola is the secretary. So they are representing this association, Student Senior. I do not know whether they are studying or not because there is nothing in the petition that they are students of their college. If they are representing this institution, this association, it has to be a registered association. Otherwise, they cannot have this association's name in the petition unless they file it individually. They are not individually coming before this honorable court.
As well as they themselves being students by themselves.
In the pleadings, I do not know. Verbally, they can say many things, but in the pleadings, they are totally silent. I definitely raise doubt because otherwise, if a student comes before this honorable court, at least they will submit their admit card or the identity card, which is not there. This petition is ditto of the earlier petition. Now coming to the second. Who are they? If lordship is pleased to come to their representation.
The first writ petition.
The first writ petition, with my lord and senior friend, Goswami Artu. Here, page 49 is the representation. To the Honorable Chief Minister on 19th of August 2021. So, exemption of JK Homeopathic College, only Ayush Medical College in Upper Assam from amalgamation into some other colleges of Assam and uplifting it as center of excellence. And who are the signatories? Possibly kindly come to page 52. Obo Goswami, senior advocate. Then Dimbeswar, ex-founder, HR and GB member. Then Kripal Sharma, ex-principal of the college. Then fourth is Rokin Soikia, treasurer of All India Tennis Association, president All Assam Tennis Association. Then Vinita, doctor, retired principal, PGT college, different college. Then there are various other persons. One is 18 lordship will see Dr. Vishwanath Portola, retired director, then RRL. So they personally have no interest, except they are hurting the interest or they are raising the interest of some other person's incomes. One submission finally came that what will happen to that family who has donated the land. This was the, I was waiting for that actually. And if lordship is pleased to look at the impugn order, page 44. Lordship will kindly come to page 45, 46. The last one, serial number 14. The existing campuses of Assam Homeopathic Medical College.
Page 46.
Page 46. I think they have not numbered it, but if it is after 44, 45, 46, I am also not saying that, but it should be 46. The third internal case of the impugn order. Serial number 14.
45A.
Here, in my there is not mentioned, so I'll put it 45. So the existing campuses of Assam Homeopathic Medical College and Hospital, Nagaon, which is Dr. J.K. Pakia Homeopathic Medical College and Hospital, Jorhat, shall be considered for utilization for the establishment of Ayush healthcare facility centers for the public, and the facility center to be established at JKSHMCH, Jorhat, maybe in the name of Dr. J.K. Pakia. So one is that it will be utilized for public utility, where there will be facilities under the Ayush Directorate, and it will be in the same name. If they are actually wanting that their name should be there, it is protected. Now, what they are saying, none of the students are before this honorable court. None of the teaching staff are before this honorable court. None of the non-teaching staff are before this honorable court. And who are before this honorable court? One scientist of RRI, one tennis office bearer, some retired persons of this institute, some senior advocate. What are they doing? If they are so interested for public interest, then I am sure this honorable court is not the right forum. Court number 2 will be the right forum for them. If it is a public interest litigation, Lordship, we'll fight it. If it is an individual case, we'll disclose every fact, law also. But first, they have to choose their right forum. Lordship is sitting singly, not taking PIL in this case. If it is converted to a PIL, I'll be very happy. Then it will have to be hardware under the High Court rules. Because they are asking for, they are praying for certiorari to set aside the appeal orders. And in that case, the law is well settled that the individual person should be personally aggrieved. His personal rights should be infringed. These are the things we have learned in our 25 years of practice.
You are talking
Somebody
on
may be
the
laughing.
you are talking on the representation.
I am talking the representation because they are the same persons.
No. Come to the list of petitioners.
List of petitions I am coming to because they are hurting on them. Who are these petitioners? Also to kindly see. Suraksha Samiti, Dr. J.K. Pakia, Homeopathic Medical College, represented by its President and Secretary. Whether it is a registered one, first question is that. I am sure they have not annexed or mentioned anything about their registration. So they have to come individually. Now, who is this? Abhijit Kumar Gogoi, President, Suraksha Committee, age 67. Arjun Mani Bhuya, 29 years, I do not know his identity, Secretary of that file. Dr. Kripal Kumar Sharma, Advisor, Suraksha Committee, age 72. Swapnapali Dr. Principal in charge of that college, 74 years. Ghono Shyamal Bora, ex-professor of that college, 74 years. Then the next one is 86 years old person, no status is given. Then paragraph 8, 64 years person, another ex-principal of the college. So these are all retired persons, whoever may be there. So their personal right is not in any manner affected. If they are espousing the cause of the public, I fully respect that. But for that, they have to go to the division bench in the form of a PL, not in the form of a petition. Because they are also saying that we do not have the power of amalgamation under the Act. They are questioning our jurisdiction. Now we are questioning their jurisdiction. This is on the point. This is on the technical point.
The students petition, they take up what we have said. And the authorities communicate to the students that what so and so college students in your pick, I can show it, madam. But then kindly down to page 20, paragraph 24 of my petition.
You can give your reply. You can give your let the Advocate General continue.
And we have also annexed this stuff. Representation given by madam or almost 60 students. We have annexed. So they are directly agreed. That's what I wanted to know. This is annexed. All right, yes.
Now, let us first start with the Constitution. Entry 25 of list 3. I will start from the Constitution and I will come to the basic facts. If the college is having 0 students, what should the government do? And whatever is done, it is permissible under the constitution, under the relevant acts of 2020 as well as the earlier act of 1973 act. Everything is permissible. Whatever provisions they are showing, that is in respect of establishing a new college. No permission, no inspection is required to close down a college. For that, what are the requirements? There will be an inspection. We have to submit a proposal. We are starting so many new medical colleges in Assam during the last 10 years. From 3 now it is 11. In 2 months time another 2 will be there. We know how the process is to be done. We have to establish the infrastructure. We have to engage the technical persons, the staff, both technical as well as the non-technical staff. Then we will request the Medical Council of India. They will come for inspection. After that, they will, if there is any deficiency, they will give us the list of deficiencies we have to meet. Then finally, the recognition is given. Same is the process under the Homeopathic Act also. Same is the process followed by the Ayurvedic colleges also. Nothing different. But to close a college, no such process is required. Neither it is written here, nor there is any requirement. What we are doing, we are closing 2 colleges, one at Noga, one at Jorhat. Why? In 2019, there is a judgment of this honorable. This honorable court said because the homeopathic teachers, they wanted higher pay scales and better facilities in terms with the central government as well as the other state government doctors. The honorable court directed, these are all part of my information. In the etiquette, everything will come. The honorable court said that the finance department and health department will have a joint meeting and decide what benefits can be given to them. During that exercise, we have come to know that in Nagaon there are 7 students and about 30 or 40 teachers. In Jorhat also the situation is equally grim. Guwahati is somehow managing. In all these colleges, there are only graduate programs. We don't have any postgraduate programs or super specific programs for the homeopathy. Then government took a decision that the director will submit a report about the functioning of these 3 colleges. The director constituted a committee headed by the principal of Guwahati Homeopathic College, the Jorhat Homeopathic College, and Noga Homeopathic College. And what is their recommendation? Let me read that recommendation. These are all proceedings of the but what is the final opinion of this 3 members committee? The director wrote to the commissioner and secretary of the government of Assam Health and Family regarding amalgamation of 3 homeopathic medical colleges and hospitals into 1 college with reference to the subject cited above.
You just have 1 copy.
Yes, I will forward. Yes, please. We have copies. Internet last page, directly go to the last page. With reference to the subject cited above, I have the honor to inform you that in pursuance of the decisions taken in the meeting held on 17/2/2020, in the conference hall of the Honorable Minister of State, Health and Family Welfare, Assam, issued by Decree 6/3/2020, in connection with the amalgamation of 3 homeopathic medical colleges into 1 college, a committee was constituted with 3 principals of homeopathic colleges of Assam. There are 3 colleges, so 3 principals are included. The committee has submitted the report. The committee has recommended to amalgamate all 3 medical colleges and hospitals into 1. The committee has suggested that Assam Homeopathic Medical College and Hospital Nagaon and Dr. J.K. Hoitia Homeopathic Medical College and Hospital Jorhat to be amalgamated with Suhit Jadhav Homeopathic Medical College Guwahati for state of the art homeopathic institution in the state with a new name, Government Homeopathic Medical College and Hospital Guwahati. The committee also recommended to allow admission into first year BHMS course for the session 2021 at Homeopathic Medical College of Guwahati only. Start PG courses soon after amalgamation. Allow pay scales of faculties as per their counterpart. Fill up post of faculties by promotion and direct recruitment as per CCH norms. Utilize the services of eligible retired faculties as per CCH norms. The report of the committee is enclosed at flat A. So this is the opinion given by the 3 experts of their own medical college, so homeopathic college. And if Lordship is pleased to know, the meeting took place on 17th, which Lordship will find at page, I think, 2-3 pages earlier. In our epidemic, we give complete facts. So this is the final outcome. And thereafter, this opinion is this was of 2020, 23/6/2020. The other day, the learned honorable judge asked us to submit a short report that I would like to place. It is, I think, it is in the record.
This one.
About 5-6 pages of here. And one more report, which is a part of the file. The first page is instructions from Compass Somos 1/2/2023.
1, 2.
2023, that later.
Yeah.
Yes. With reference to the above, I am directed to submit here with the following information in relation to WPC 398 of 2023, which will come upon 2nd June 2023. The details of students admitted in different homeopathic colleges in the state. Lordship will kindly see the left side. Number of students in SIR, this is the Guwahati. Here, the total intake capacity is 63. Total admission is 43 in the first year. Then second year also 63, 23 is there. Third year 23 out of 63 were filled up. And fourth year 18. This is Guwahati. Now taking the second college, AMCH, that is Nagaon. First year out of 63, only 22 students were admitted. Then out of 63, 6. Then third year 0, fourth year 0. Then in Jorhat, out of 63, 28 are there, then 23, 16, and 12. So huge deficiency of students are there. With 0 students, we are maintaining the whole faculties, the government. As a result, neither the college is improving, nor the faculty members are doing their exercise properly, nor the institution is growing. And all these colleges do not have, and further I am reading further. This year for the academic year 22-23, the candidates for admission into BHMS, that is the graduation course, have been selected against the state quota 54 numbers at SJN Homeopathic College, Guwahati, by the selection board whose counseling, and after completion of counseling, 20 number of student seats are lying vacant due to non-availability of eligible students for the BMHS course. Now, this time when we have amalgamated all 3, there are only admission in 1 college out of 189, total 6 available for us in 3 colleges is 189, from which we have got only 22 are still vacant. Report of the number of patients attended the last 5 years of Assam Homeopathic Medical College Hospital and Jibokanto JK Soikia Homeopathic Medical College Hospital, Jorhat, and close for daily reference. That Lordship will kindly see. Next page is there. Maybe bigger. If we take an example of last page number 4, last page, Jorhat. 2018 total OPD 4526 and IPD, that is nil. Then 2019 2019, 4,616 IPD nil. Then 5,100, then IPD nil. In 2022, OPD 8,000 and IPD 248. So this is the number which is very nominal. So the government, in its wisdom, thought it that let us have one good institution of high quality where all this can be accommodated. Now, the issue is whether we have the power to amalgamate or not. One policy is there. What we are doing actually, we are closing two policies. Section 44 they were hurting. Now, what is section 44? Section 44, the other side was, sorry, 47. Section 47 of the 2020 Act, National Commission for Homeopathy Act 2020. Section 47 says, notwithstanding anything contained in this Act, any student who was studying for a degree or diploma in medical institution immediately before the commencement of this Act shall continue to do so, study and complete this course for such degree or diploma, and such institutions shall continue to provide instruction and hold examination for such students in accordance with the syllabus and studies as existed before such commencement, and such students shall be deemed to have completed this course of study under this Act and shall be awarded degree or diploma under this Act. Now coming to the next two. Notwithstanding anything contained in this Act, where recognition granted to a medical institution has lapsed, where by influx of time or by its voluntary surrender, or for any other reason whatsoever. Now, Nagaon is going to give up its recognition. Jorhat also is going to give up its recognition. We are giving up. So what will happen to these students? They will study in the Guwahati institution. Whether they will be pursuing the same course, yes, they will be pursuing the same course. Whether they will be pursuing the same syllabus, yes, we cannot tinker with the syllabus. For tinkering with the syllabus, we have to go to the central authority. And all these colleges are under the directorate of Ayush, Government of Assam.
What is section 44?
Sorry, this is 47 actually. 44 is not really relevant. 47. So the proviso itself provides a situation which is now prevailing in Assam. That notwithstanding anything contained in this Act where recognition granted to a medical college has lapsed. Because certainly this time it will be lapsed because there will be no proposal for extension of the recognition for 22-23 session. Every year we have to take recognition, whether it is MBBS course or other courses. So when Nagaon proposal will not go, proposal from Jorhat will not go, there will be no visit or inspection from the central authority. So it will lapse. But it is a deliberate action on the part of the government that we are closing it. When there are no students in the college, government does not want to run the show without a student, without there being a beneficiary. So notwithstanding anything contained in this Act where recognition granted to a medical institution has lapsed. So this year it is lapsed. If Lordship passes an interim order, then it will be a big problem for the students because they will not be able to take admission. The admission has already been done in Guwahati. There is no recognition for Nagaon as well as Jorhat as on date. The renewal has not taken place. Whatsoever such medical institutions shall continue to maintain and provide minimum student standard as approved by the Commission till such that as all the candidates are able to complete their studies in that institutions. So now, Guwahati's recognition is there. The students already shifted because that document, the secondary petition they have annexed. I have not got up-to-date instructions, but whatever is
No,
there
if-
from their record,
No, if my understanding is correct, if
Lordship,
my reading is correct,
Lordship,
even if it is de-recognized,
yes,
they shall continue to study in that institution till they finish the course.
till they finish the course,
Yes.
no admission.
How can you stop no admission when the act contemplates?
What we can always transfer shift. If you suppose MBBS course, there is no bar of transferring one student from another college. If the students are willingly coming to Guwahati and studying, what is the bar? This third party's interference is not required. Lord. They are the third party. They do not have any interest. Neither their children are studying homeopathy. These people who are before this honorable court, whether their children are studying in these colleges. Somebody else are studying. Somebody else will go to a better institution where there are full faculty members, where there is a scope for upliftment of the institution. They are not before this honorable court. Somebody wants to play politics, somebody wants to play sentiment. That is happening here. Somebody's family name is not there. They are aggrieved. Who will think about the plight of the students? And the government, public action, the lordship's tax money, my tax money, will have to go to the proper person who is imparting education. When there are no students, but still they are enjoying the benefits. We want their work to be effectively done. Not sitting idle in Nogam without earning any student. We have amalgamated everywhere. This is rationalization. If we have violated, lordship will definitely interfere. But whether we have interfered, I will come to that legal aspects of it. Facts I am placing so that I can have a better understanding of the law while placing my submissions finally. One document with the secondary petition they have annexed, and my learned senior standards placed it also. That page 56 of the subsequent petition.
Subsequent means students' union.
The associations, medical students association, students unions.
Yes.
Page 56. The 38th January's notice. It is hereby informed that all students of AMCH Nogam and JPS HMC Jorat, who are now the students of Amalgamated Homeopathic Medical College, shifted by letter dated 25/1/2023 and 27/1/2023 respectively, that their classes will be started from 1st February 2023 at SIN Homeopathic Medical College and Hospital. All students should attend their classes regularly to get their required eligible percentage for NCT University final examination. But these students are not before this honorable court. That is the problem. Whether the classes have started or not, I am asking for the information, it will come. So my humble submission is that lordship, even if lordship wants to issue notice, till now notice has not been issued. Notice may be issued on the point of maintainability first. If it is maintainable, lordship will definitely look into the merit of the case. But to satisfy on merit also, I would like to make submissions. Entry 25 of list 3. Whether the state government has the authority to control and frame policies for running the education in the state or not. Concurrent is list 3.
The state list or the concurrent?
Concurrent list 3. Entry 25. Entry 25 says education including technical education, medical education. So homeopathy will come under medical education, and university is subject to the provisions of entry 63 64, 65, 66 of list 1, vocational and technical training of labor. So my humble submission is that state has exclusive authority to run the education, subject to the condition as per the entry 63, 64, 65, and 60. Let us go to these three entries now. '63 of list 1, that is central list. '63 says the institutions known at the commencement of this constitution as the Benares Hindu University, Aligarh Muslim University, and Delhi University established in pursuance of the Article 371E, and other institutions declared by Parliament by law to be an institution of national importance. Whether Jorhat institution falls under 63? No. 2. Institution of scientific or technical education financed by the government of India wholly or in part and declared by Parliament by law to be institution of national importance. They will have to say no here also. These are state governments exclusive running institutions. And neither it was declared by Parliament also. 65. Union agencies and institutions for professional, vocational, technical training, including the training of police officers. So this is not a union agency, neither it is an union institution. Jorhat 1. I am skipping BCD because the main heading is not covering it. And 66. Coordination and determination of standard of in institutions for higher education of research and scientific and technical institutions. One submission is that medical is not included here. Number 2, coordination and determination of standard. Are we diluting the standard of Jorhat vis-a-vis Nagaon or Guwahati, or Guwahati vis-a-vis the other three? We are not. We are not changing the syllabus. We are not changing the parameters of education. Neither we are increasing the number of seats. Whatever permission is given to us by the central authority, because we have to submit a scheme at the beginning to get the recognition, to have this uniform standard. We cannot dilute on that. How many subjects will be taught, what are the subjects, whether we have proper laboratories, library facilities, technical persons, the teaching staff, everything is being monitored and maintained by this central authority. Every year we have to renew. But in the instant case, closing one institution, taking their students to another institution, whether that will come under entry 66? No, in my humble submission. We are not changing the parameters, the standards, or the quality of those institutions. For that, we have to go to the central acts. So under Constitution, entry 25 empowers the state government to frame any policy on education, if it is not in violation of entries 63, 64, 65, and 66 of list 1. So we have the jurisdiction in my humble submission. Now, the other side was with lot of provisions from these two acts of 2020 and 1973. What are these two acts? What is the objective and preamble of these two acts? This 20 Lordship will kindly take the first act of 1973.
1973 Act.
Homeopathic Central Council Act 1973.
Okay.
Lordship will come to the index of that act.
I have only the 2020.
The other 1973 act is also there. I think they have not placed it.
No.
Then I have to place it. Meetings they have, I think. Because according to them, the institution was established in 1975. So this act will also have some relevance. May I read it slowly, Lord? So, arrangement of sections. The chapters I'm reading. The preliminary section says short title, extent, commencement, then definitions. Then chapter 2, Central Council and its committees. Constitution of Central Committee, mode of election, etc. Chapter 2A says 12, section 12A and 12B. Permission for establishment of new medical institutions, new course of study, etc., which is relevant. 12B says non-recognition of medical qualification in certain cases. Then chapter 3, recognition of medical qualifications. Chapter 4, central registry of homeopathy. After these students become doctors, they have to maintain a register. Then chapter 5, miscellaneous. So what is relevant in our case is chapter 2A. Chapter 2A includes two provisions of the section Act, 12A and 12B. May I read two provisions of section 12, chapter 2A. Section 12A says permission for establishment of new medical institutions, new course of study, etc. Notwithstanding anything contained in this act or any law for the time being in force, no person shall establish a homeopathic medical college or no homeopathic college shall open new or higher course of study or training, which would enable students of each course of training and qualify himself for award of any recognized medical qualification, increase its admission capacity in any course of study or training, including postgraduate courses of study, except with the previous sanction of the central government obtained in accordance with the provisions of this section. At present, the three medical colleges of Assam have 189 seats permission. We cannot go here. We cannot admit a student who is 190 or 191. But our case is much low. Now 0, Jorhat 28. That is the average. In Guwahati, I think 42 or something. And this time, only one college allowed the admission, where also 22 seats were lying vacant. So this is the position. So what we have done, maybe we have used the term amalgamation in a loose manner, but actually in practical, effectively, two homeopathic colleges are closed down. What will be the effect of that? Where will the students study? Where will the teaching and non-teaching staff will go? They were all brought to Guwahati, and under the provisions of the permission which we have already have, they are accommodated here, and therefore they are not raising any grievance before any forum. They are not before this honorable court. Neither they went to the honorable chief minister. They have annexed one representative to the chief minister. That's why I am saying that. So everybody is happy except few persons who does not have any business there, except some emotional, sentimental issues. What will happen to the name of the family who has donated the land? Yes, the land will always be there. Nobody is going to take that land. There will be institution of Ayush, which will be of public utility. And the name will also remain JKFI. His family persons are also not here. His family members are, what I am reading, Lord, are not before this honorable court. They are also happy. It will be upgraded now. So that is the situation. So whether we have violated any law, this 1973 Act stipulates all these conditions for establishment of new medical college or new course of study, which is not the case here. Guwahati institution is already there.
Just let me know whether the classes have started.
Yes, I have spotted information. It's not coming till now. All the officers are in the G20, lots of the things are going on. In the DC office also, not a single person is available. That is the problem for last 4-5 years. It will continue up to 8 project. And therefore, the government is taking their service during the vacation also. On 9th and 10th, they will all enjoy holidays. That is all beyond the point of this case. But we are trying to get the information. One thing is very clear, not a single student is here. The student union's president and secretary are they students? I am raising this question. Where is your identity card? You are coming to the honorable board. First, establish your identity. Everybody can say, I also become a secretary of all Assam Students Union without having any identity card. Will that do? I'm raising that question now. This is factually incorrect. And they cannot represent any association now because the association cannot come before this honorable court unless it is a registered one. The law is well settled for this high court. They have, if it is registered, then they should annex the registration. I am raising this. They have to counter it by placing the registration certificate. Not even the registration number is mentioned. In which class they are studying, they are saying subsequently when I make this submission that he is a student or she is a student. In which class, which year? And they are saying in the year that there is no hostel facility. I am trying to give the complete facts. Whether the Guwahati Medical Homeopathic Institution or college is not having hostel facilities. I'm sure it has. There is another college, Cotton College, or now university. 80% of the hostel seats are remaining vacant now. Earlier it was a different story 20 years ago. It is very difficult to get a seat in the hostel than a seat in the course. Now courses, the students are here, but in hostel, 80% of the hostels are remaining empty. If that be the case, I will make a submission before this honorable court. If the student comes that they are not being able to come to Guwahati because there is no hostel facility, we will convince the government to give some hostel from Cotton College for the student till the hostel facility is made available. I'm sure that is not the case. So in which way we have violated the law, Lord? Absolutely, constitution authority is there. We have the source of power. Anti 25 is very clear. These are policy decisions. And the main stakeholders who should be agreed are not before this honorable court. At this stage, my humble submission is that this petition has to be decided on the point of maintainability at this stage. All the subsequent things will follow. I just apprised this honorable court on merit also. I am not taking the course of technical evidence to say or defend the case. Either way, we are on a strong footing. But first, if they are really urging the case of the public of Jorhat, if they have sentiment for Jorhat people, definitely, Lordship, they have to file a PI, not a of certiorari.
Thank you.
Highly obliged.
I'll issue notice. Admission notice. Court, Mr. D.K. Goswami, and Mr. Counsel. Assisted by Mr. D.B. Bura, learned counsel for the petition. In the first case, issue notice. Mr. B. Gogoi, learned standing counsel.
Health and family welfare.
Health and Family Welfare. Appears on behalf of the respondents. Who appears for union? MS CGC appears for respondent number 1. B. Google and standing counsel.
For health.
Appears for 2. Four, 5, 6, 7. How about this committee for amalgamation of 9, 10, 11?
The three principals, Lordship. We'll represent them, Lordship.
All these 8, 9, 10.
Committee 8. Also, speaking which one, Lord?
You
398 or the other one?
the first case.
The first is 398. So here we represent we represent 4, 5, 6,
4, 5.
7, 8, 9, 10, 11, 12, and 12.
About one,
The central government.
one year there,
Krishna.
and how about three?
3 also, I think, central government. Maybe they may have individual council also. But registered notice may go to them.
Petitioner to take steps for service of notice on respondents 3 and 11
311. Yes.
by registered post 80. The respondents are allowed to file counter affidavits. The issue of maintainability raised by the learned advocate general is kept off. Stop. Yes, Gogo, any instruction where the
Yes,
classes have
I
started?
have received. Okay. From Nagaon, everybody has come and started their classes here. From Jorhat, out of 111 in 4 years, 70 has already joined here, and rest have telephoned that they are even joining today or tomorrow.
Stop. List the matter of the 4 weeks. The prayer for entry shall be considered on the next.
Highly appreciated.
Same order. In the second case, 1 minute. In the second case, Mr. C. AC Borber, AC Borber, assisted by and Borbatra Boy.
I don't exactly I am.
Okay. One. In the first case, I, Mr. AC Borber, the city council for the applicant submits that he is not pressing the person. Accordingly, I is disposed of. And in the second case, but AC Borber assisted by so and so issue notice. And MS B. Sharma, the CGC appears for 1. And here,
Parties are same note.
same.
Same. Copy paste the both of it, except 2 paragraphs.
No. 2, 3, and 12. 2, 3, and 12 by registered post. 2, 3, and 12. In the first case also, I think it is 2, 3, and 12.
I think only 1.
Yeah, first case also 2, 3, and 12. By registered post. 2, 3, and 12.
Also, I think only 1 observation. The issue of maintainability may be kept.
I've said that.
No, no.
They-
Highly
So what are the interim orders?
I'm considering it on the next day. Now all the students have joined. All the students have
No,
joined.
that's not the correct position. Nagaon is not before election. We are Jorhat.
Jorhat, they are joining today.
70 already joined. 100.
No, I don't agree with that. Your logic will consider.
That is the status.
Yes, that there is.
If we have joined, then there is
Lordship,
status.
they are doing.
No.
Now, if the students come and say,
There is status quo as of today.
No, sir.
some students will not be able to study.
No, your logic will kindly take care.
Some Naugong has come.
70.
No, we are not.
No, that's fine. Naugong has come. Jorhat, how many has come?
70 out of 111.
And the remaining are joining today or
We
tomorrow.
do not have any reason to speak false here.
And the factual,
The class has also started.
factual.
Lordship will kindly appreciate the external interference in the student's life. This is what is
I'll take up after 2 weeks.
on affidavit will be.
Interim, on the interim, you make your submission saying that students have joined. Otherwise, if I pass in status quo order or an interim order today, what happens to the students from Jorhat? Those who have
40
joined,
students, 41.
those who are coming to join today, and those who are joining tomorrow, what happens? Yes, please.
We are now, first of all, let us consider the legality of the order.
Yes.
That's the primary thing. This is a position of, closing down this institution. And
No, let them file the affidavit. I'll take up after 2 weeks.
can you maintain the status quo? Otherwise, the whole.
No, no,
We came before the
status
law.
quo, if I maintain,
Yes.
half the students of Johat are already enrolled.
And
remaining are coming.
That is absolutely incorrect.
No, one thing is Advocate General is making a statement.
Maybe.
I have to trust the Advocate General of Assam.
That information has come from the director. That the also Lordship will report.
My kindly take the annexure A of my petition, the signatories of the students.
No, I'm not on that.
All the signatories.
Okay, just put like this. Then at Advocate General Assam. Further submits that the
Upon instructions from the
submits on instructions from the Director Ayush, Government of Assam, that the classes have started with effect from
classes started. From the record also it is visible.
from 1st February 2023, and out of 111
70 has already.
students from the which university is that?
Jorhat.
Dr. J.K. Saikia,
JK sir, yeah.
Homeopathic Medical College, Johat. How many has joined?
70 out of 111.
70 has already joined,
About that, I dispute this, as on today.
and as on today, and remaining students will be joining
Yes, joining today or tomorrow.
within the by today or tomorrow.
This is they are contacting our officials.
In that we have to make
If somebody is restrained, then we have to inform.
prayer for entry shall be considered only after 2 weeks.
The issue of maintenance also will be
I'm not
considered.
keeping it up.
Look, Mary only said this. We fight this case.
No, you may have filed it earlier.
What I'm saying is,
But impugn order is of 29th November.
we just complete my. We have moved this to earlier opinions. Because said that the interim order will be passed. Has not been. And it is now before your lordship. Your lordship has ordered that for the hearing that we got from you. Now, the position is that by postponing this interim order, on the earlier 2 occasions, the situation has been created to our disadvantage.
No, the question is,
Because if the first day it was, it's up to your lordship, either to grant the prayer we are making or not to grant. But we will have our avenues against that order. Suppose your lordship either allows, they can go on appeal. If it is rejected, they can go on appeal against that order. Now, by postponing to earlier
Okay.
occasions, you have created a
in view of the so-and-so made by the learned Advocate General, that so-and-so has joined classes, and the remaining so-and-so are going to join by today and tomorrow. I'm not inclined to pass any interim.
That's right. My lordship only observe. The figures given, I object as on that so many.
That-
Whatever
Yeah,
you
that
decide,
you can decide. Up to 4 weeks.
Item 15. So we are getting application.
Hmm.
Today I have received a copy of the petition here, filed by my learned friend. Some of that is also required because we want to be a party respondent. The main petition. So that will come on record on Thursday. Some alternative is on the part of my learned friend. May I make some submission? What transferred of the applicant before the lawsuit. But what happened in this matter? The applicant before the lawsuit is a regular principal. He was of diet. He was transferred from diet Kachar to diet Hailakandi. The writ petitioner below, he is still a senior lecturer. Senior lecturer is a feeder post to the post of principal. So he is yet to go in the cadre of principal, and he has filed a writ petition saying all these things that rule has been violated. He has the right to get promotion to the post of principal, and I transferred from Kachar to Hailakandi, wherein he is holding the post of principal as in charge. His right of consideration will be violated, and he will be deprived of his promotion. That was the case made up in the writ petition. Now, my simple submission is that writ petition is not favorable on the basis of the record because he is not a person aggrieved in this matter. He was holding the post of principal diet as in charge below. He is still a senior lecturer.
Let
He is still to
Let the IA come, we'll take it up on Thursday. There's no harm. We'll take up on Thursday.
In my respectful submission, my lord, there is no requirement of any IA to decide.
Let us see, since that IA is already filed, let us have a look at the IA also. Who has filed the IA? Gurga is the, you filed the IA.
Perhaps the so-called take your losses for a moment. Kindly bear with me for sir. Also, kindly take up the IA, the stability petition for a moment.
Yes.
Also, will kindly come page 45. And it's a D6.
Yes.
Second portion of this order, below. In the interest of public service, Abdul Noor Bormia, that is the applicant before the lawsuit, principal diet Kachar Udarbun is hereby transferred and posted at diet Hailakandi in the same capacity against existing vacant post. Dr. Jibendu Dutta, senior lecturer of diet Kachar, is hereby allowed to take over the charge of in-charge principal of diet Kachar from Abdul Noor Bormia. So, Abdul Noor Bormia was at diet Kachar Udarbun. Therefore, it's a substantive appointment, regular principal he is. Therefore, he is transferred to diet Hailakandi, wherein the writ petitioner, he was working as in-charge principal. He is senior lecturer, yet to be principal. Now, in diet Kachar, this Jibendu Dutta, he was a senior lecturer. So, since the diet Kachar principal post was vacant, so Jibendu Dutta was given the in charge. Now, this writ petitioner, he came before this court saying that if I am transferred to diet Hailakandi, the post of principal will be occupied, and he is in the zone of consideration for promotion to the post of principal. So, he wants that he should be promoted at diet Hailakandi. Look, is it a proposition of law? Can you claim that upon promotion, I want to be posted at diet Hailakandi? Because this is a centralized category. All over Assam diet, it's a centralized thing. You can get promotion to anywhere. Then why are you hampering this transfer process? A person has to have some grievance. Where is his grievance? He doesn't have any grievance to challenge this impugn order. There is not. First of all, you have to become a principal. You are in charge, and also will kindly see the order by which he was holding the post as in charge.
Page.
I just take it. Also, will kindly take up the repetition for a moment. Lordship is page 116. Page 116. The second part. Constituent upon joining of state so and so as senior lecturer Diet Hailakandi is senior lecturer. He is temporarily allowed to hold the current charge, that is in charge principal Diet Hailakandi, along with financial power under the provision of FR so and so SR as per finance establishment OM dated so and so without statutory power which effect from the date of taking over charge until further orders or till full-fledged principal is posted, whichever is earlier, in addition to his own duties. Your posting order as in charge principal of Diet Hailakandi itself specifies that you have to give way to the regular principal. When the government has posted a regular principal at Diet Hailakandi, now you are coming up with a plea that your promotional revenue will be curtailed. That is the plea that is in the decision. Your promotion will take. I am not concerned about your promotion. You take in your regular due course of action. So far as I am concerned, I have been transferred from Diet Kacha to Diet Hailakandi as a principal. I am going to retire in the month of October. I am a permanent resident of Hailakandi. Government has transferred me at the pride end of my service career to Diet Hailakandi. And if you don't have any grievance, you cannot have any grievance because you are still to born in the cadre of principal, and you got an order from this court. You also will kindly see the order passed by this court. Whatever reason you cannot have a grievance. Any other person can have a grievance against that. Page 30.
Page
Page 30 of the IMA.
30.
Page 30 of the IMA.
Yes.
Para 2. The petitioner is a senior lecturer in arts education in the District Institute of Education and Training, DIET, and pursuant to the notification number so and so, dated 19/12/2018, the petitioner on 21/12/2018 joined as principal in charge of DIET Karimganj. While serving at DIET, Karimganj DIET, the state government in the elementary education department by notification number so and so, dated 28/12/2021. Transferred the petitioner and posted him as senior lecturer at Diet Hailakandi. And further, by the said notification dated so and so, the said authority temporarily allowed the petitioner to hold the current charge of in-charge principal of Diet Hailakandi, along with financial powers under the provision of so and so, and finance department office memorandum number so and so, without statutory power, with effect from the date of taking over charge until further order, or till full-fledged principal is posted, whichever is earlier, in addition to his own duties. That order I have read just before me. Since 1/1/2022, the petitioner on his joining on the same transfer dated so and so is serving as senior lecturer and principal in charge of Diet Hailakandi. It is stated that the Assam District Institute of Educational Training Diet Service Rules 2010, a statutory service rule under Article 309 of the Constitution of India, regulating the recruitment and condition of service of persons appointed to the Assam District Institute of Educational Training Service, came into force with effect from 29/12/2010 on the publication of the same 2010 rules in Assam Gazette Extraordinary. As per the provisions of Rule 5 of the same 2010 service rule, the post of principal of Diet is to be filled up by promotion from the select list of vice principal, senior lecturer, having not less than 10 years of service, 10 years of experience as lecturer, senior lecturer, or vice principal. The petitioner's name figured at seniority position 37 in the gradation list of senior lecturer of Diet that was published on 26/2/2021 by the Director of Elementary Education, Assam. Being not satisfied with his seniority position as reflected in the same final gradation list of senior lecturer of Diet published on 26/2/2021,
The petitioner preferred a writ petition being WPC number so and so, wherein the court on so and so, while issuing notice to the respondent, therein, in the interim, suspended the judicial list dated so and so pertaining to the seniority of the senior lecturer of diet of state respondent. The state government in the Department of School Education by notification number so and so transferred one Srimati Dulami Haren's principal of diet Hemaji and posted her at diet Lakhimpur in the same capacity against the existing vacant post in the interest of public service, providing further that the senior most lecturer of diet Hemaji shall take over the charge of in-charge principal of diet Hemaji from Said Srimati Dulami Haren's immediately. The state government in the Department of School Education by the same notification dated 22/12/2022, right number so and so, transferred the respondent number 6, that is the applicant herein below, to principal of diet Kasha Udargan and posted him at diet Hailakandi in the same capacity against the existing vacant post in the interest of public service, allowing one Dr. Jivendu Dutta, senior lecturer of diet Kasha, to take over the charge of in-charge principal of diet Kasha from respondent number 6. The petitioner being aggrieved with such transfer of the respondent number 6 as the regular principal diet Hailakandi has preferred this petition, stating that, or this is important, the post of principal of diet as provided under the statutory rules of 2010 can be filled up by way of promotion only, and the existing vacant post of principal diet cannot be filled up by way of transfer. He tried to say that the post which is he is holding as in charge basis, the regular principal is post is vacant. I have been transferred to that post, and the petitioner's pleaded case is that that post can only be filled up by way of promotion, not by way of transfer. That is the proposition of law. In my respectful submission, Milord, that cannot be. It's a centralized cadre. You will get your promotion on your turn. You can be posted anywhere. Can you claim that upon promotion to the post of principal, I have to be posted only in the post of diet Hailakandi? It cannot be, Milord.
Continue.
Pursuant to the order of the court dated so and so, the respondent state government in the Department of School Education, Assam, through the learned council for the same department, placed the relevant written information under number so and so in the matter, which goes to show that Srimati so and so, principal of diet Hemaji, submitted an application to the director of SCERT Assam for her transfer from diet Hemaji to diet Lakhimpur due to her family personal problem against the existing vacant post due to the retirement of the regular principal of diet Lakhimpur on 31/10/2022. Similarly, with regard to the respondent number 6, that is the applicant here, it is seen that the MLA of Kacha recommended the transfer of respondent number 6, principal of diet Kacha, to diet Kacha to diet Hailakandi against the existing vacant post, requesting the authority concerned to allow one Jivendra Dutta, senior lecturer of diet Kacha, to hold the current charge of principal of diet Kacha in place of respondent number 6. Those requests were forwarded to the authorities concerned in the Department of School Education of the state by the director of SCERT Assam, and matters were accordingly placed before the authority concerned. Since regular principals of diet at Hemaji and Kachar did not complete 2 years of their continuous service as principal in their respective diets, the matter was placed before the concerned minister for necessary approval. Accordingly, the departmental minister concerned approves such transfer. However, with the observation that both the transfer may be approved in public interest, though in the case of Said Srimati so and so Hemati, it was at her request, and in the case of respondent number 6, it was at the request of MLA of Kachar for his transfer to diet Hailakandi, with specific request that one Sri so and so should be allowed to hold the charge of principal at diet Kachar. Accordingly, by the interim notification number so and so dated so and so, Sri so and so, principal of diet MRG, has been transferred and posted her at diet Lakhimpur in the same capacity against the existing vacant post in the interest of public service. And similarly, by notification number so and so, the state government in the Department of School Education transferred the respondent number 6 from the post of principal of diet Kachar and posted him at diet Hailakandi in the same capacity against the existing vacant post in the interest of public service, allowing Sri
petitioner has submitted that the transfer of the respondent number 6 is not only in violation of same 2010 rules, but only to accommodate the same respondent and Dr. So senior lecturer of Gayat Kachar, that too in the personal request of MLA Kachar, and therefore such transfer is arbitrary in nature. Then I will skip para 18. Then para 20. Considering the relevant instructions placed before the court today, noted as above, it is found that the balance of convenience for the issuance of interim order is in favor of the petitioner. As such, the interim order of transfer of respondent number 6 as principal by Hailakandi in terms of notification issued by the state government shall remain suspended until further order of the court. Not this is the direction. So far as the recommendation made by the MLA and consequential approval of the minister is concerned, that law is absolutely well settled by the Honorable Court in the division bench. That can be done. The concerned MLA as well as the minister has got the power in their capacity to transfer a person from one place to another. Now the another question is that violation of Rule 5 of 2010 rule. This is absolutely clear that there is no violation of Rule 5 because you cannot claim one particular course upon your promotion. Even assuming for a moment that yes, the MLA has recommended and the minister has approved the file, my submission is that you have to be person aggrieved before approaching this court below. You have to have some demand. Can you claim any right over that post that I have to be posted there? Can you substantiate before this court that you are a regular principal and you have a right to be posted there below? No such thing. He approached this court projecting a case that 2000 Rule 5 of 2010 was violated. And accordingly, this court, after consulting the records, and so far as this Jivendu Doctor is concerned, the IA that has been filed.
Learned counsel, I think we can dispose of the main petition. Isn't that better?
Lordship, it can be done. Even
Yes,
today also,
we
the
are-
process
Yes,
was.
my lord, I am ready because even today, my lord, the affidavit has not come from the government, and the case, my lord, which has been protected by my respected friend, not so simple. There are certain issues which are required to be adjudicated, my lord. We are governed in a country, my lord, which is governed by the rule of law, and this is a classic example of that where the rule of law has been violated at the behest of the MLAs and ministers. That cannot be allowed, my lord. I will satisfy my lordship in that regard also.
Yes, government who's appearing. Yes, Bora.
Main case can be performed on Thursday,
That will be another affidavit of the government, subject to what my lord would finally say. It's not required. I can demonstrate that from the rules. He says, my lord, that rule only contemplates a promotion. So nobody can be transferred to. That's basically my lord establishment.
I've got the point.
Lordship, my lord would just test that contention in the repetition. My lord, one page if your lordship can just check out, my lord. I'll show that. If your lordship can come to page 114.
114.
My lord, that rule contemplates there are three categories of lecturer, senior lecturer, or vice principal, and my lord principal. Now, from lecturer, it's a direct entry. The post of senior lecturer, my lord, is a promotional post. Same like that of principal, it will be promoted from the cadre of lecturer. And my lord, principal will be promoted from the cadre of senior lecturer, vice principal. So the submission of my friend would be that nobody can be transferred. If there is a vacancy, you will have to fill in up by promotion. That should be. Same analogy will also apply for the post of senior lecturer. And therein also, my lord, because it's a promotional post, so nobody can be proper transfer. Now, my lord will come to answer. Okay. The repetition. My lord, my friend's client, Tajuddin Laskar, say, in the interest of public service, Mohammad Tajuddin Laskar, senior lecturer, died, Karimganj. So he was promoted to that post earlier. He is hereby transferred and subsequently posted as senior lecturer at Hailakandi. He himself came on transfer.
That means be the senior lecturer also, that rule 5 itself, Malak says that it's a promotional. One of these issues have been gone into by the Supreme Court. One decision of the Supreme Court, I think Malak have to clarify the issue. 1983 SCC, page 29. Copy, Malak, unfortunately, the copy of Malak. If Malak can have it in Malak's. Page 29.
Mr. Bora?
Malak,
No,
Malak
you
can
can
consider the issue, Malak.
Take a verbal instruction on me. No need to file an affidavit in this type of transfer matters. Just indicate the. So the
Malak,
issue-
whatever they have to say, it's there in the honorable single judge's order.
Yeah,
I admit that there may be an interference by the minister or the MLA. And there's a division bench judgment of that. But Malak, what right my friend has to block it? In that 1980 case, Malak, same issue, wherein my lord a post was created, same rules like this, that should be filled up by promotion. The petitioner said, fill it up by promotion. My lord said it was, post was created in Guwahati, and the petitioner was also in Guwahati, that case. Said you should promote it. They did not promote it. They brought somebody from Dibrugarh and filled up that post. And the post in Dibrugarh was open to that person. He said, how can you? Then the Supreme Court said, nothing doing. It's a creation of a post in the cadre. You can fill it up. It's not that you should fill it up where the vacancy occurs. You can fill it up at any point. Only requirement is there should be a vacancy. So my lord, only problem here is my lord, I'm hanging. My lord, I have to go back because of the interim directions, because the honorable court had passed an order, we comply.
Bora, can we have it on Thursday?
Thursday, fine. Thursday, my lord. Okay. Oh, but it's getting, because I'm also on the verge of retirement. Oh, my lord, that will not give him any advantage. My lord passed an order, I comply with it. That much only. My lord will not hold it against me.
Transfer order is also cancelled, by the government.
On the request made by the parties, this is the matter of 14th.
My friend says the transfer order is cancelled. I said, you withdraw the petition, you got the relief.
But this transfer is really cancelled.
No. It's not because of the interim order itself.
We'll see.
Right. Thursday, 14.
14th.
What's up? Online.
The main party will be the Karbiangan. The issue is that I am before the largest single judge on a review application on a liberty granted by the division bench to final review application. But the issue was we have challenged the petitioner and the selection for the post of some teachers in Karbiangan, where in the advertisement it was stated that the Reservation Act has to be followed. Thereafter, the judgment which is under review, prior to that, they have considered the reservation has to be followed. Now, when this present petition, which order is under challenge, was under adjudication, the Karbiangan District Council stated that they have not followed the reservation act. The evidence was not on break. But the largest single judge, while passing the judgment, has not considered that. That was placed before the division bench. So division bench gave us a liberty to further review application. But now today I don't find the Karbiangan council. So let it be on 15th para. Karbiangan now then I place it. Now that particular
Sutya, you're ready?
For final disposal in any other
Mr. P.K. Chaudhary, learned counsel for petition. On request made by Mr. T.C. Shutia, learned J. Shutia, learned counsel for the learned standing counsel, Karvi Anand. When do you want?
On 21st or 28th. 28th. Then second.
Mr. Metro. Second of for final.
Aye.
This method pertains to some person collecting of results of my English course. We have completed all our course. We have also completed our final examination. Only one subject was clear from past semester, which as per the regulation we are within time. We are not permitted to sit. Later we came to the court by interim order, we were allowed to sit. Just the results was to be given. They are withholding. Now we have filed an IA to see by the last order.
In the IA?
No, not in the IA, in the main petition.
Yes.
The court has detailed out the order that require some hearing. Now, for such hearing, because there are another set of petitioners in the division bench, which are not within the chances as provided by the rule. Therefore, we have challenged the rule there. But here we are within the rule. Now, they have filed an affidavit in those cases where they have referred to this petition, saying that they are within time. That affidavit, I bring it on record. In petition 828, they have filed it. Petition 828, and some more documents. Otherwise, it is according to results in urgent. Therefore, it's on Monday for final. Just the results. This will not in fact require a final hearing also. We are within the rule, but they also admit it.
Yes.
Monday.
On request made by the parties. This matter is 13th. You want?
Of supplementary list. Order.
In this case, I appear to the institution. Private referendum, the principal has filed an application for early hearing. So probably today they have not appeared. I have checked the name of the applicant. The council is not shown in the policy. Probably that is why they have not appeared.
So IA, the party name is not there.
And filing this in this case is already listed in the part 2 hearing list at item number 7.
So what shall we do with the direct to reflect Mr. Mukta? SK Mukta, is it?
Yes. His name will be shown listed. Yes.
Registry is directed to reflect the name of Mr. SK Mukta, Learned Counsel, appearing on behalf of the applicants. And list is submitted again after a week. After a week.
Then of daily hearing.
This is a matter where I had argued against that my part was complete. The state was to respond. This is a matter pertaining to closure of the Assam Agro Industry Development Corporation. And these were people, there were options invited either to opt for BRS or for re-employment. We are the group of people who opted for re-employment. So initially although there was a very clear promised, they were not appointing us. Ultimately, we approached this honorable court. This honorable court went into the matter in depth, issued a direction to issue appointment orders within 6 weeks, which they did not comply with. They went up in a week. The appeal was also dismissed. Ultimately, they appointed us after about 4 years. And naturally, my lord, in the meantime, many of these people were almost on the verge of retirement. Some retired immediately on being given appointment. The main challenge before your lordship in this case is that while giving us the appointment, they treated us as fresh appointments. And if that is taken care of, all the reliefs that we are seeking for automatically will follow. That was, in a nutshell, that is the case. In fact, I had made arguments for almost 3 hours. Your lordship wants me to refresh. So I can do
Where
that.
is Arbora?
One Mr. P. Nayak was appearing
That is finance.
finance.
And Arbora for agriculture department.
And these people have been waiting, in fact, unfortunate as it is, on 3-4 occasions it was heard and plans, but ultimately again they sought for some time, some accommodation. Ultimately, this is how I don't know. But if the lordship makes it clear, the lordship fixes it again on Thursday, day after tomorrow, and let them make their submissions. This matter needs to be closed. Otherwise, there are some people who are absolutely in a very bad state. On the last occasion also, the day I made my submissions, on that day also they had sought for 1 or 2 days time to give their reply. Unless your lordship passes an order saying that no further time will be granted, I don't think they will be.
Mr. I. Chaudhary, then Senior Counsel, assisted by Mr.
Yes, Bishop.
Yes, Vishwakarma, then the counsel for the petition. Yes, Nayak, yeah, yes. Where is your agriculture department? Okay. Mr. P. Nayak, then the Standing Council, Finance Department, Standing Council appears on behalf of Finance Department. One appears for the Agriculture Department. Stop. Please the matter again on Thursday, 9th February. It is made clear that no further adjournment shall be granted on the next date.
Thank you.
11.
All people are going to this, relating to? Yes. He has completed his arguments, I think. Yes. And Kataki, your for
Secondly, this is that might not only deletion. Switch over absolutely private conducting. It's not government conducting. So it will mainly market. Because might not private conducting ICSF will still pay. So in the eye of law, in my respective submission, not be a discount here. The real mother going to understand it is intra-government department or in inter-government department. Lordship is wherever I did not study your lordship with that respect for the letter. Now, having switched to on this own volition, so ICICI initially for a period of 2 years, he refused to come back. And he was given communication. He said, my lord, father, email has been given to the parent department to come back, which he refused. And my lord, by that way, a flux of time was consumed, my lord, more than 5 years. Now, more than 5 years, he was outside his job, primary job. And he continued, my lord. He continued in a private life. Then he made up his mind to come back again to the parent department. Parent department might have examined the matter, it took some amount of time. Finally, he was allowed to join it and become. Now he is reported to the report. Now he has filed my lord.
Who is the petitioner's counsel?
Petitioner, perhaps he is on late number 6. Maybe because justice Shyam. So if I review, we may like to reply to my contention. But I also do not like to make any adverse arguments in this absence. Because since
Okay,
I am
none appears for the petition. Mr. R. Bovujal is an standing counsel for finance. No, then standing counsel appears for finance department. And MS Kataki, then standing counsel appears for the enable investment department. We'll have it on Friday, Thursday.
Some part of the can it be? On
Tuesday,
Tuesday, 14.
14. So we're fixing it on the 14th. Yeah. Okay, then don't say none appears. H. Bital. None appears. List the matter. Again on 14th.
Okay. And so,
Well,
now the list no numbers are back because I am no longer the president. School has been amalgamated, I have been revised by every. Nothing surprising this petition now. Doctor, this is the notification school has been merged.
You have a spare copy?
Yes, yes. School has been merged, but my status has been referred back to as a teacher only, assistant teacher. Because it is the base school headmaster or headmistress will be the headmaster, and not the amalgamated school.
Oh. Then
Nothing surprised now.
If it is not
And one more,
survived,
and the lead petitioner is now the assistant headmistress of a different school. She has been transferred to a different school.
Then
Her position is much better than me now.
on request made by MS ADB, then the consequent petition. This is the matter after.
that's it, may check this document, let's see, I take instruction and maybe reflected in the output.
Yeah, list the matter. When do you want?
After 4 weeks, 4 weeks. 1 week.
List the matter after 2 weeks to enable to receive instructions in terms of the order dated 33/2022, by which the Bikyadar Memorial High School Johat was amalgamated with Johat Gitardi Vidyalaya. Stop. After 2 weeks, fix a date.
24. Therefore, motion item 5.
So, motion item. Not tomorrow, it will be difficult. Registry also has some difficulty. Who is appearing for the petitioner? Okay, in the morning he was there.
Yes.
Heard RL Chutiel in the council for the petition. It is submitted that Learned Advocate General Assam will be appearing in the matter. And therefore prays that the matter be listed on 14th or 13th, Monday. 14 is a hearing day. On 13th. Praise the Lord. List according.